was a video playing on the screen in my courtroom, not evidence I had subpoenaed, not footage from a security camera. Her video, published to her own platform, 7 months before the proceeding began. I want you to understand what that means before I tell you anything else about this case, because everything that follows turns on the specific fact that the record she was asking me to ignore was the record she had made herself. What do you call it when someone walks into a federal courtroom claiming harm and the evidence playing on the screen behind them is their own? I have been on this bench for 4 years in Chicago, and I have asked myself that question many times since I closed this case. My name is Isaiah Webb. I am a federal judge, and what I do on this channel is open the door to rooms the public does not usually enter and tell you exactly what the record said. Not the version that traveled, the version that existed. If that is the kind of account you have been looking for, subscribe and hit the bell. These cases stay here. They do not disappear. And if something in what you are about to hear brings a line to mind, from a book, from something someone once told you, from anywhere, write it in the comments. I read them. In a few minutes, you will understand why I started where I started. Because the case does not begin where you might expect it to begin. It begins with a folder. 41 pages, 11 years. I want to ask you something before I tell you what happened in my courtroom last month. And I want you to sit with the question because the entire case turns on it. What do you call it when a person walks into a legal proceeding claiming harm, and the record we are about to examine is the record of what they actually did? I want you to hold that question, because I held it for the entirety of that proceeding, and what I found when I finally answered it was not complicated. It was clarifying in the specific way that a finding is clarifying when the facts do not leave room for interpretation, when the record says exactly one thing, and the only question that remains is whether the person on the other side of the bench is going to acknowledge what the record says or continue performing something else entirely. She arrived before her attorneys did. That is the first thing I noticed. Not because arriving early is a problem, it is not, but because of what she did when she arrived. She walked to the plaintiff's side of the room first. She looked at it. Then she looked at the small business owner who was already seated, a woman named Elena who had run her establishment on the north side of this city for 11 years, who had come to my courtroom alone except for her attorney and a single manila folder that she placed on the table in front of her, and did not move from that moment until I asked for it. The influencer, and I am going to call her by her role in this proceeding because her name is not what this case is about, looked at Elena the way people look at things they have decided are smaller than they are. Then she sat down on her own side of the room and took out her phone. Her lead attorney placed an appearance folder on the table that was roughly 4 inches thick. A second attorney arranged a laptop. A third was arranging something on a separate cart near the wall. I counted 3 attorneys present for the plaintiff. I watched Elena place her hands flat on the table beside her folder, look straight ahead, and breathe. I have been on this bench for 4 years. I clerked before that, practiced before that, taught before that, and spent 5 years as a federal public defender sitting on the other side of a room exactly like this one, watching people arrive who had resources and watching people arrive who had 11 years of work in a folder. I knew what the morning was going to feel like before a word was spoken. I have been wrong about that sense before. I was not wrong this morning. What I want to name, before I tell you what the proceeding produced, is something I observed in that room before the record was formally opened. I want to name it because it is the thing that this case is actually about, and naming it clearly at the beginning is the only honest way to tell you what happened at the end. The influencer had, at the time this case came before me, approximately 4 million followers across her platforms. Her attorney had entered this figure into the preliminary record as context for the damages claim. The theory being that her endorsement of a business carried measurable commercial value, and that her denial of that endorsement, by extension, represented a kind of loss. I had read this argument in the filing. I had read it carefully. I had spent some time with the specific legal theory it was constructing, which was a theory that a person's audience constitutes a form of leverage in commercial interactions, and that a business's refusal to acknowledge that leverage amounts to a cognizable harm. I want to be precise about this because precision here is the entire case. The law I work with every day does not have a category for follower counts. There is no statute in the Northern District of Illinois and no federal provision relevant to this proceeding that establishes a person's social media reach as a protected interest, a commercial entitlement, or a basis for damages. The law has categories for discrimination, for fraud, for tortious interference, for defamation, for intentional infliction of harm. It does not have a category for someone who believes their audience size entitled them to terms unavailable to other customers. and who experienced the denial of those terms as an injury. I had identified, before Elena's attorney had said a single word, that the damages theory the plaintiff was advancing would not survive examination. What I had not yet fully understood, because the filing, read in isolation, did not make it entirely clear, was that the question of who had been harmed in this situation was not, in fact, close. Elena's folder contained 41 pages. I know this because I asked for it midway through the proceeding and counted. 41 pages for 11 years of work and 3 weeks of damage. The first 20 pages were her business records, revenue figures, customer frequency data, vendor contracts, the lease on her space that she had renewed twice. The next 12 pages were screenshots, 43 one-star reviews, time-stamped, every one of them posted within a 72-hour window beginning the day after the influencer's visit. The last 9 pages were the output of a reputation management firm she had hired, at a cost she specified to the penny, attempting to address what those 72 hours had done to 11 years. I read those 41 pages the night before the proceeding. I have not forgotten a single one. The influencer's complaint described the visit to Elena's establishment in specific terms. She had arrived with a member of her team. She had requested what her complaint called preferential service arrangements, priority scheduling, complimentary services in exchange for promotional content, and access to the establishment outside of its published operating hours. Elena had declined. According to the complaint, this declination was experienced as humiliating, as a deliberate affront to the plaintiff's professional standing, and as the proximate cause of the reputational harm the plaintiff had subsequently suffered when she chose to share her experience with her audience. I want to read that last clause again because it is doing a great deal of work in the complaint that it should not be doing. When she chose to share her experience, within 4 hours of leaving Elena's establishment, the influencer had published a video. The video described her visit. It named the business. It described Elena by first name and physical description. It characterized the refusal as disrespectful, as the behavior of someone who did not understand how things worked, and it included, and I am going to be exact about this, a direct statement to her audience that the establishment deserved to hear from them. Not a suggestion, a statement. She told 4 million people that a small business on the north side of Chicago deserved to hear from them. Within 72 hours, 43 reviews had been posted. Elena's revenue for the 3 weeks that followed was documented in that folder. I do not need to tell you what the numbers showed. Her lead attorney, when the proceeding was underway, presented the damages theory with the confidence of someone who had constructed an argument they found genuinely persuasive. The influencer had suffered reputational harm, he argued. Her brand had been damaged by the association with a negative experience. Her audience had seen her treated without the respect her professional standing warranted. He used the phrase professional standing several times. He used the word entitled once, and I watched him register that he had used it and decide it was accurate and proceed. I asked him to define professional standing for the record. He paused. He said it referred to her position as a public figure with a significant platform and a documented history of commercial partnerships. I asked him whether that position, as he had defined it, created any legal obligation on the part of a private business to provide services on terms different from those offered to the general public. He said it created a commercial incentive. I asked him to identify the statute under which a commercial incentive becomes a legal entitlement. He referenced a case from the Southern District that was not on point. I told him it was not on point and asked again. The room was quiet for a moment that I would estimate lasted about 10 seconds and felt considerably longer. His client was watching me during this exchange with an expression I have seen in other proceedings, the expression of someone who has prepared for a number of outcomes and is beginning to understand that the one unfolding is not among them. She had been sitting with a particular posture since the session opened, a posture I can only describe as expectant, leaning slightly forward, hands folded, the posture of someone waiting for a proceeding to reach the part where their position is acknowledged. She was still waiting. What happened next in that room is what I have thought about most in the weeks since. Elena's attorney stood and asked permission to introduce an exhibit. I granted it. The exhibit was a link to a video. My clerk put it on the screen at the front of the courtroom. The same screen I use for documentary evidence, for surveillance footage, for the kinds of records that are easier to see than to describe. The video began playing. It was the video the influencer had published the afternoon of her visit to Elena's establishment. The same video that had produced the 43 reviews. The same video that was cited in Elena's complaint as the basis for damages. What the video showed was not what the complaint had described. I want to be careful here because I am not in the business of editorializing about evidence. The evidence is what it is. What I will tell you is that the interaction between the influencer and Elena's staff, captured on the influencer's own camera by the influencer's own choice and published to her own platform, did not show the humiliation the complaint described. It showed a request made. It showed the request declined courteously by a staff member who explained that the establishment did not offer complimentary services in exchange for promotional content, that their scheduling operated on a standard appointment basis available to all customers, and that they appreciated her interest. It showed the influencer's response to that declination, which was not the quiet disappointment the complaint characterized. And it showed what followed. She had filmed it herself. She had posted it herself. It had been publicly available for 7 months before this proceeding began. Her attorneys had not addressed it in the filing. I do not know whether they had seen it. I know that Elena's attorney had seen it because it was Exhibit 1. I watched the influencer watch the screen while the video played. I have spent 4 years developing the specific judicial practice of watching people in my courtroom look at evidence, not to evaluate their guilt by their expression. That is not what evidence of demeanor provides, but because a person's relationship to a piece of evidence tells you something about how the proceeding is going to go. She watched the screen with the particular attention of someone who knows exactly what is on it and is calculating in real time what the room is now going to do with it. The video ran for 3 minutes and 47 seconds. When it ended, the room had a quality of silence I have only encountered a handful of times in 4 years on this bench. Not the silence of surprise, the silence of something having been confirmed. Everyone in that room, her attorneys, Elena's attorney, the clerk, the gallery, had arrived at the same place at the same time without anyone needing to speak. I let the silence sit for a moment. Then I asked her lead attorney whether he wanted to address Exhibit 1 before we proceeded. He asked for a brief recess. I granted 15 minutes. When we reconvened, the damages theory had been substantially revised. The theory of professional standing had been withdrawn. A new argument was being offered, that the post and its consequences were protected expression, that the plaintiff had the right to share her experience with her audience, and that the resulting reviews, whatever their content, represented the organic response of her followers and could not be attributed to her as a legal matter. This is where I want to define something carefully, because the distinction matters, and I want to be honest with you about how I reasoned through it. She did have the right to share her experience. That right is not in question, and was not in question in my courtroom. She can post what she likes about her experience at any business. The First Amendment protects that, and I take that protection seriously. But the right to speak is not the same as immunity from the consequences of what speech produces when the speech is specifically designed to produce those consequences. There is a difference between sharing an experience and directing an audience. There is a difference between saying I had a negative visit and telling 4 million people that a specific small business deserves to hear from them. The first is expression. The second is something the law has words for. The word I used in my ruling is willful. Willful infliction of harm through coordinated action. The statute I applied provides under those circumstances for damages in an amount up to 3 times the documented loss. The documented loss was specific because Elena had documented it to the penny. I made the finding the statute required. I applied the multiplier the statute authorized. I want to tell you what happened in the room when I read the number. She had been throughout the proceeding in the posture I described, expectant, waiting for the proceeding to arrive at the part she had prepared for. When I read the number, that posture changed. Not dramatically. She did not react the way people sometimes react in proceedings when a sentence is delivered. The gasp, the visible collapse. It was quieter than that. It was the specific physical change of someone who has been holding a position they believed was solid, discovering that the ground beneath it has moved. The room went quiet again. Different from the silence after the video. That silence was the silence of confirmation. This silence was the silence of consequence. A particular kind of peace that only a room like that one can produce, when what has been said is accurate, and everyone present knows it, and the record now holds it permanently. Elena sat with her hands on the table beside her folder. I noticed that her hands were still. I noticed that she did not look at the other side of the room. She looked at her folder, and then she looked at me, and I gave her the small acknowledgement that I can give in a formal proceeding, which is to hold her gaze for a moment before I move to close. She received what 11 years of work deserved to receive. That is what the ruling produced. Not celebration, Not vindication in the theatrical sense, something quieter and more permanent. The record now says what happened. The record says who was harmed. The record says who did the harming. And the record says that those two things are not the same person, regardless of the follower count. I have been sitting with this case since I closed it. I have been sitting with it because it contains something I want to name directly, something I want to be honest with you about, because I think it is the actual question this proceeding raised, and I do not want to wrap it in language that makes it easier to hold than it actually is. There is a version of this story where the person who published that video did not think of what she was doing as a weapon. She thought of it as sharing. She thought of it as content. She thought of it as the ordinary act of telling her audience about her day. I do not know what she thought. I know what the evidence showed. But I want to be honest about the question because I think it is the question that stays with me. Does the intent change the harm? If someone deploys 4 million people toward a small business without intending the word deploys, without thinking of it that way, without calling it that even to themselves, does the 41-page folder get thinner? The answer the law gives me is no. The harm is the harm. The intent is relevant to the level of the finding, but the harm does not depend on the perpetrator's self-understanding. What I am sitting with is not whether I ruled correctly. I ruled correctly, and the record holds that. But what it means that someone can cause the kind of damage Elena's folder documented without ever once thinking of themselves as someone who causes damage. I am 41 years old. I have been on this bench for 4 years. I am still learning what the decisions require of me. This one required me to hold two things simultaneously: the law, which was clear, and the question beneath the law, which is harder. The law answered the case. The question beneath it I am still carrying. What I want to leave you with is not the verdict. The verdict is in the record. What I want to leave you with is the question I asked myself sitting with Elena's 41-page folder the night before that proceeding. What does it mean to cause harm you have decided doesn't count as harm because of what you've called it? What does it mean to walk into a proceeding performing the posture of someone who has been wronged, when the evidence in the folder on the other table is the record of what you actually did? I am not asking you to judge her. That is my job, and I did it. I am asking you something different. I am opening the question to you because I believe the viewer in this room, the person who has watched this case with me, is capable of answering it from their own experience. You have been in a room like that one, or near one, or you have watched someone hold a position of certainty right up to the moment the record arrived. You know what that looks like. I want to know what you call it. Not what I called it in my ruling, what you call it. Write it in the comments, I read them. This case deserves witnesses, and the comments section is where the witnesses gather. If what you heard today is the kind of account you have been looking for, the actual reasoning, not the summary, the weight of it, not the headline, I would be glad to have you here. Subscribe, hit the bell. What I bring to this channel is the same thing I brought to that bench last month and the month before. The record as it was, the reasoning that produced it, and the honest account of what making the decision cost. These cases do not disappear from here. They stay on record. The same way Elena's folder stays on record. The same way the ruling stays. She will pay the number I named in that room. Elena will return to her 11 years. The record will hold what happened. I am carrying the question beneath it, and I expect I will be for some time. That is the job. That is what it is supposed to feel like.